Hi everyone, welcome to our briefing today on the draft criminal laws and the impact of the laws on the digital ecosystem. In fact, just yesterday, the parliamentary bulletin came out and the three laws have been listed for consideration and passing this winter session, so next month. So this call couldn't happen at a better time. Uh, Before I begin, just a couple of things. We are focusing only on the digital aspects or the aspects that affect digital life and the digital ecosystem. So we're not looking at the bill in its entirety, which is a lot, as you can imagine. And also, we are not experts in criminal law, so do take what we say with a grain of salt. And if there are others who want to step in at any point from the audience who have a better idea of something we've said, please do join in. And with that, the things that we are looking to cover today are basically the provisions in the three draft laws which impact the digital ecosystem. How do the bills treat search and seizure of electronic devices? How do they regulate uh, speech online in terms of hate speech, defamation? How do they look at issues like cyber stalking and voyeurism? And how do the bills treat digital evidence? And lastly, we look at how the parliamentary committee, which examined the three laws, it submitted its report a few weeks back. So we look at what those reports say and what are the suggestions that have been offered. So the three laws that we're looking at, so they are the replacements for the Code of Criminal Procedure of 1973, the Indian Penal Code of 1860, and the Indian Evidence Act of 1872. So these are the three laws that make up the bedrock of the criminal system in the country. And they will be replaced by the Bharatiya Nagrik Suraksha Sanhita, the Bharatiya Nyaya Sanhita, and the Bharatiya Sakshya Bill. The reason that the government says that it's introduced these new laws is that the existing laws are colonial and outdated. They don't account for the digital advances that have been made, the technological advances. Existing laws were meant to punish. The new laws will serve justice. Not exactly sure what it means, but these are the remarks that were made by the Home Minister in the Parliament. And the new laws are also expected to be more human-centric. We'll start with the CrPC replacement, which is the Bharatiya Nagrik Suraksha Sanhita. This is the law that talks about search and seizure of evidence. So Section 64 of the law of the bill says that any court or police officer can summon any document required for investigation as evidence. But the important thing now compared to the CrPC is that uh, any document could include digital evidence. And under digital evidence, we have messages, call recordings, emails, and any kind of conversation that takes place to electronic media, as well as electronic devices themselves, like mobile phones, laptops, cameras. And the government also has a provision there where they can mention an electronic device as covered as digital evidence on a later date through a notification. And if there is reason to believe that the person who has been asked to provide this electronic evidence does not submit them, then the court has the right to order search and seizure. There's also Section 185, which allows the police officer to look or search for anything, even without a court order, if there is reason to believe that the thing cannot be obtained without a delay otherwise, and if it's necessary for the purpose of an investigation. So it's not necessary that a court order has to be obtained for obtaining the electronic device in certain cases. Why is this problematic? If you take both those sections that we just talked about, there are three issues that arise. One, it might encroach the right to privacy. Electronic devices, mobiles, laptops contain a lot about us. It contains our entire digital lives. In fact, it contains photos, messages, sensitive details like password, credit cards, and all this might be more than what's required for the case, but the police will have access to the device in its entirety. Then there's right against self-incrimination. There might also be content in these devices which are privileged conversation with lawyers and other details which could uh, interfere with the right against self-incrimination. Or the legal backing, especially the Section 185 that I described in the previous slide, It also increases the ability for law enforcement to demand phones and laptops arbitrarily. If you remember the incident in Hyderabad back in October 2021, the police randomly stopped and searched the devices of people on the street. They looked at the WhatsApp messages for potential drug-related conversations. When this happened, it was criticized. There were actually lawyers who took this to the court. They filed petitions saying that this kind of search is not legal. Uh, there were legal grounds to challenge it then, but now if with the new law, it might legitimize such kind of searches uh, because it allows the police to do so for any reasonable purpose. How is it different? We already touched upon it, but basically the CrPC does not explicitly include the words electronic and digital, but digital evidence was still collected and summoned and searched under the category of other things. But because it was not explicitly mentioned, there was no clarity on how digital evidence should be processed or collected. And as a result, there are multiple cases pending in various courts across the country. Especially if you look at the Wire, NewsClick, and the Bima Koregaon case, there's a lot of questions about how electronic devices have been seized in the past and how they are problematic. As a result, the Supreme Court earlier, like I think a couple of weeks back, a month back, asked for guidelines on search and seizure of electronic devices. Uh, there are draft guidelines. These just came out a week ago. So the Supreme Court put this out. Uh, so these draft guidelines basically say whenever you're searching and seizing a electronic device, it should be based on a judicial warrant. It cannot be a warrantless search, and only if it's directly part of the crime under investigation. And also, the device has to be examined by an independent agency within 24 hours in the presence of the owner so that a hash value can be created. Owners also have the right to remove irrelevant information and they cannot be forced to share their passwords. These are just draft guidelines. They're not enforced. They're not legally enforced anywhere. So we'll have to see the mechanism for how it might be. But the reason I put it out here is to point out that the safeguards that are outlined in the draft guidelines, although this just came out, but there's nothing similar. Similar kind of safeguards are missing from the bill. We would have expected something like that to be included in the law so that it's not being done arbitrarily, but alas, that's not the case. And even the parliamentary committee report, the Parliamentary Standing Committee on Home Affairs, did not have any comments or suggestions for the provisions related to search and seizure of electronic devices. The only mention of this provision is in the dissent note of Derek O'Brien. So he talks about he similar to the points we've raised in the previous slide. He talks about how it can be an invasion to the right to privacy and against the right against self-incrimination because of the amount of personal data that is in these devices. The other major aspect about this bill is that it requires digitization of the legal system end to end. So from the process of filing an FIR to the filing of the charge sheet by the police to the delivery of the judgment, it wants it to be digitized and delivered through electronic channels. It also allows the appearances of witness, accused, experts, and victims uh, through electronic means. They don't have to visit the court physically, and issuing of summons can also be done through electronic means. And it also says that if there is any search and seizure being done, it should be audio video recorded. For these specific provisions, the parliamentary committee report does have some suggestions. It says that before you require digitization of the entire legal system, establish robust safeguards so to ensure that the any electronic data cannot be tampered with or any unauthorized access cannot take place. As for the electronic FIRs, it says that the law should spell out which electronic modes are accepted for FIRs because based on the current wording, it could be construed that sending an SMS to a police officer is considered as filing an FIR. To avoid that kind of ambiguity and logistical challenges, it asks the government to lay out specifically what modes can be used. So these are the suggestions the parliamentary committee has offered on the digital aspects, but it still hasn't given any comments on the search and seizure of electronic devices. I'll hand it over to Aarti to go over the other two bills.
Thanks a lot, Sarvesh. Hi, everyone. Thank you for joining us this afternoon. I start off with the Bharatiya Nyaya Sanhita 2023, which is supposed to replace the Indian Penal Code of 1860. There are sort of various themes in terms of what the bill does. So we're kind of going to bracket it in this presentation into different buckets to make it easier. So the first one that we're looking at is essentially speech. Now, the big sort of fanfare with this bill when it came in was that it would essentially remove the IPC's clause on sedition, which, as you know, is the subject of pending litigation at the Supreme Court as well. Sedition essentially criminalizes various acts and kinds of speech that encourage disaffection or anti-state sentiments. And while the bill does actually remove explicitly that provision, what it also does simultaneously is introduce a new section which criminalizes using electronic communications or financial means to commit acts that excite or attempt to excite secession, armed rebellion, subversive activities, or any act really that endangers India's sovereignty. And the punishment, of course, in this case for that new crime is either life imprisonment, imprisonment of up to 7 years, and or a fine. Now, the concern here, which various commentators have raised, is essentially that introducing a provision like this while taking away sedition actually doesn't, uh, nullify the offense. In effect, it brings sedition back, just with a much larger scope and with harsher punishments. And sedition, the reason it's been contentious over the last few decades or so is essentially because of the impacts that it has on free speech. So by bringing in a much harsher provision that also caters to the online realm as well, we could see impacts on free speech in the future as well. And this is a point that's been raised by almost all the MPs who dissented against these three bills during the committee proceedings. Now, it's not to say that the committee didn't recognize this concern or recognize this contradiction. In its report, it essentially acknowledges the fact that sedition has been taken out and replaced with something that seems similar in terms of the kind of speech it polices. But following extensive deliberations, the committee's sort of conclusion on this contradiction was fairly tempered. What it said was essentially that it compliments the government for deleting sedition without actually compromising India's security, and that in general it finds it to be a very progressive development. So overall, I think we would need more commentary, perhaps from the lawyers after this discussion on the implications of a provision like this. Up next, we have defamation. Now, defamation again was also an offense under the IPC. It's not necessarily new in that sense, but something that my colleagues actually pointed out was that it essentially extends the definition of defamation itself. Of course, defamation in sort of an intuitive sense includes speech that would malign someone's reputation, but in this case, they've given various examples of what that could constitute. And in this case, it could be in the speech expressed in the form of an alternative, or ironically, that could also constitute defamation as well. And the bill gives an example, for example, of how you speak ironically to say question the person's character and mislead an audience as well. And what some of my colleagues essentially argued was that this could hurt various types of speech that are made in a satirical way or in a comedic way, because a lot of those art forms, for lack of a better word, do rely on forms of alternative speech or ironic speech to make a certain political or just social point. And it's interesting in this case because even there's a current challenge against a fact check amendment that's being brought by the Indian government at the Bombay High Court. And in the government's counter affidavit, they sort of talk about the different kinds of information that could be fact checked by this unit, and that includes satire. And the government, sort of in very flowing language, says that yes, we do support satire, we encourage it, we want people to speak freely, but it also says satire should come with a disclaimer and it should be clear always that satire is not a fact, as what would be reported, say, by a news house like MediaNama. So this sort of development comes amidst that larger tide of perhaps shifting regulatory attitudes towards satire, ironic speech, and comedy itself. The committee didn't have anything explicit to say on this, nor did most of the MPs who were dissenting against the bills. In his dissent note, Mr. Chidambaram of the Congress Party mentioned that defamation can be retained as an offense, but a limitation period should be provided within which a person may be prosecuted. So that was sort of the limited commentary that we had in this angle as well. And again, coming back to misinformation and fact check units, the bill also introduces a provision criminalizing using electronic communications to publish false or misleading information that jeopardizes India's security, sovereignty, and much more. And naturally, the thresholds for false, misleading, or even just the qualification for jeopardizing effects aren't really specified in the bill. And similar to the fact check amendment, I think the concern over here is that you're giving the government or the prosecuting agency the power to determine what constitutes false or misleading information and what that threshold might be. And again, that comes with consequences for free speech online. And this is not a provision that the committee has commented on either. Now, this is just like, these are the most important ones in our estimation, but there are various other provisions on speech in the Sanhita that are not significant departures from the Indian Penal Code. What they essentially do is take the old provision, rewrite it a little bit, and also extend that provision to electronic communications and digital mediums. So, for example, in the Indian Penal Code, if you had statements conducing to public mischief offline being an offense, in the Sanhita, doing that online or using electronic communication to commit that crime would also be an offense. So it's essentially just digitizing the provision, for lack of a better word. And there are various different types of sections that do this, and the committee hasn't really commented on any of them. And from our reading, neither have the dissent notes as well. And that was the end of the free speech bucket. And now we'll kind of come to the sexual offenses one and the sexual crimes one. And in a welcome move, while the IPC has always looked at the question of voyeurism, what the Sanhita does is essentially understand that questions of, non-consensually stalking or non-consensually tracking people can happen online as well. And that's a concern that has to be accounted for by criminal law. So it does criminalize voyeurism online as well. And that would include watching or capturing women engaging in private acts where they have expectations of privacy or disseminating such footage. And even if the woman has actually consented to having this image or footage taken, but not to their dissemination, then that constitutes an offense as well. Now, the concern over here is essentially that while the provision frames the perpetrator as a person of any gender, could be a woman, a man, or a trans person, the victim of this crime is solely framed as a woman. And this could potentially leave out both men and trans persons out of the section's scope. And I'd love to hear from the folks who are actually, in the thick of it after this call to basically understand, how do these provisions actually get operationalized when, you have a victim who's not really a woman, but has still suffered the same crime. And the committee actually didn't touch upon this. It did recognize the provision and said it's important to have it given the rising number of cases where people are sort of stalked and the images are shared non-consensually online. But this concern specifically was not addressed by the committee in its review. And in a similar line, the committee also looks at questions of stalking online, what I've described as just cyber stalking essentially, and it criminalizes stalking by men who monitor women online, whether on the internet or over email or other forms of electronic communications. And in this case, stalking could also include contacting a woman despite her clearly indicating that she's disinterested. And the same concern appears over here. In this case, it's even more limited. Both the victim is solely framed as a woman and the perpetrator is solely framed as a man. And again, you could be leaving out swathes of victims who who are impacted by such crimes as well. And the committee has not commented on this either. And now finally, these aren't hugely important provisions, but maybe we just included them because we thought whoever's tuning in here, they might find them interesting and have a different perspective for the off-record call that happens after this. But there were some interesting ones. So while the IPC has always criminalized forgery and different types of forgery, something interesting here was this Sanhita criminalizes forging electronic records issued by the government, ID cards issued by the government, and that can include a voter card, birth certificate, and sort of the popular Aadhaar card as well. And there's a specific kind of threshold for what forgery entails as well. So given the number of Aadhaar-related crimes and sort of scams that are happening, this could be an interesting provision to keep an eye on. And not something the committee has commented on either. And then the next one and the last one in the section is essentially on encryption. And the Sanhita looks at encryption and says essentially that it is a crime to use it to conceal information when you're committing a crime that would otherwise be punished with life imprisonment or a death sentence. So given that we've sort of seen trends of the government being concerned over the fact that certain kinds of apps and platforms are being used to perpetuate crime online. Again, this is an interesting provision to keep an eye out for in terms of how it might be used as well. And the committee has not commented on that either. So that sort of brings us to an end of the end of our presentation on the Nyaya Sanhita. And now we'll be looking at the Bharatiya Sakshya Bill 2023, which is set to replace the Indian Evidence Act of 1872. And to be fair, this is a bill that we were it's quite technical, it's quite dense, it's designed for a certain audience. So this is something we'd love for the people in the audience also to talk about more in the off-record portion in terms of reading between the lines. How does this impact digital rights? Because on the face of it, it's all a little opaque. So, for example, while the Indian Evidence Act has always, through amendments, of course, acknowledged the question of electronic records and electronic documents being used as evidence in cases, what this bill does is essentially put it up front and center instead of as an afterthought or as an amendment. It kind of includes it in the entire corpus from the get-go. So for example, electronic records can include emails, server logs, locational evidence, voicemail, and these records would essentially have the same legal effect during your proceedings or investigation as a paper record would. And there are also powers included to essentially deem certain electronic records as documents as well, according to specific parameters. And finally, there's also some amount of purpose limitation mentioned as well. I think Sarvesh in his presentation was talking about how it might be concerning, how you might have a large amount of information being provided to an investigating agency that they may not really need. In the case of court proceedings, what they've essentially said is that limited evidence will be provided and nothing more than what the court deems necessary to fully understand the statement should be given. And these are sort of the broader provisions that we identified that could impact how evidence is collected and used in proceedings as well. Now, this is an area where the committee did actually have constructive feedback to provide. And it highlighted the very important fact that digital evidence, sorry, one second. It highlighted the fact that digital evidence can be tampered with and is prone to tampering rather. So they recommended including a clause that might mandate that digital evidence that's collected during an investigation is handled securely and processed according to a correct chain of custody. And they also, yeah, and Deepak just has a comment that the Evidence Act was also amended by Schedule 2 of the IT Act 2000. Thanks for that, Deepak. And the committee also recommended in a sort of secondary comment that the bill's schedule, which essentially entails a form that has to be submitted by the police to certify electronic evidence in an investigation, that needs to be amended as well to conform to the requirements of presenting electronic evidence in proceedings. So those are sort of the limited comments that the committee had on this. And just coming back to this question of self-incrimination that Sarvesh raised during the first part of the presentation, again, I'm not sure how this links, but it would be interesting to hear during the discussion. One thing that the bill mentions is that witnesses cannot be excused from answering relevant questions in proceedings on the ground that doing so would criminate them. And they also say that, but in the same vein, what they also say is that in the case of electronic records, no one can be compelled into producing a record that they control, that any other person controlling the record would be entitled to refuse to. So there's sort of, in my mind, a little bit of a contradiction there. So I would be interested to learn about how everyone else views that as well. And again, on a parting note from the committee sort of was generally, this was generally a shorter report, and the committee was uh, steadfast in its belief that the bill will help bring in a new wave of digital evidence into criminal proceedings that is necessary and relevant for the 21st century. So that's sort of a general overview of how the next two criminal law bills look at digital rights online and might impact digital rights online. And we've covered this extensively at MediaNama. We have summaries of all the laws. We have summaries of how the committees have reported on them. And of course, lots of court reporting on how the Supreme Court and High Courts have addressed these issues as well. Sarvesh, if you'd like to take over from here.
Yeah, we can move to the questions, guys, if you have anything. Rakesh, we can stop recording.